Today is the last day of the Supreme Court's term. That means Trump v. Barba, the Birthright citizenship case, drops today. Done. Final. No more waiting.
Wow.
And this one's been hanging over everything. ABC News calls it one of the most anticipated rulings of the year. Roughly 150,000 children born on U.S. soil each year are in the crosshairs.
150,000 per year. And Trump went on Truth Social before the ruling even came out and said he expected to lose. You know what nobody wants to say? That's not legal strategy. That's a man with a clock ticking.
And he attended oral arguments in person, first sitting president on record to do that.
Historic for all the wrong reasons, depending on who you ask. So we are going to walk through every layer of this, the government's legal argument, why it didn't land in the courtroom, and what the two paths to a ruling actually look like.
That second path is the one cable news is going to completely miss. There's a narrow statutory route under the 1952 Immigration and Nationality Act that leaves the constitutional question open entirely. Future fight.
And while everyone's watching Birthright, the DOJ is running a parallel track. CBS News reported the administration is targeting 250 denaturalization cases by October, as in revoking citizenship from people who already have it.
That's an entirely different legal mechanism, different courts, different standards. We'll pull those two tracks apart.
Two tracks, one ruling dropping today, and a Truth Social post from the president basically calling his own shot.
So the clock's been running since about 10 a.m. Eastern this morning.
Then let's get to work. First segment, we start where the case started, what the government actually argued, and why it didn't land. Before we dive in, a quick reminder, we love hearing from you. If you have questions or topics you'd like us to cover, head to the link in the description and submit your question. We read every single one. So here's what's going on today. And I mean today, right now, this morning. The Supreme Court is sitting on the last day of its term, 4 cases still pending. One of them is Trump v. Barbara, the Birthright citizenship ruling. And if they don't drop it today, they adjourn for the summer.
Wow.
That's the clock we're watching.
That's the procedural reality. ABC News confirmed the court must rule before summer recess. Today is it.
Today is it. And look, everybody's been pretending they understand this case all week. The anchors, the panels, the whole circus. But here's what most of them won't tell you. Trump himself already told you how this ends. On Truth Social in May, he posted that a negative ruling on birthright citizenship is not economically sustainable for the United States of America. The President of the United States predicted his own loss in writing.
To be fair, and I think this matters, Trump also attended the oral arguments in April, first sitting president to do that in the official record. He sat in that courtroom, heard the justices' questions, and apparently reached the same conclusion the legal analysts did.
Trump has to pay attention. He's definitely not surprised. SCOTUS blog said after oral argument, the court appeared likely to side against him, which means the president watched the hearing, went home, and posted what amounts to a concession speech on social media, weeks before the ruling.
Preemptive grievance. It's a genre now.
It is. And look, the executive order has never once been enforced, blocked continuously since January 25, 2025, over a year and a half of injunctions. The ACLU estimates this ruling could affect the citizenship status of more than 200,000 children born to immigrant parents every year.
Which means the stakes aren't abstract. That number represents real families in legal limbo right now, waiting on 9 justices.
Exactly right. And the question that nobody's actually answered yet, what does the Constitution say word for word, and does this executive order survive contact with it? So, the text, 4 words, subject to the jurisdiction thereof. The whole fight lives right there.
And the administration didn't argue that those words mean something new. That's the tell. They went back to Wong Kim Ark, the 1898 case, and said, look, domicile was in there, that's the key.
They borrowed the precedent they were trying to beat.
Exactly. The Library of Congress CRS brief lays this out precisely. The Solicitor General told Justice Sotomayor directly, "We're not asking you to overrule Wong Kim Ark. We're asking you to read it differently. Domicile appeared in that 1898 case, therefore domicile is the constitutional threshold."
Which sounds clever
Until you realize why domicile appeared. Wong's parents had been in San Francisco for over 20 years. Nobody disputed that. It was stipulated background fact. The holding didn't turn on it.
So they took a footnote-level detail and tried to make it the whole argument.
Right. And the 14th Amendment doesn't say domicile, it says jurisdiction. Congress chose that word in 1868, then reused it verbatim in the 1952 Immigration and Nationality Act. Justice Kavanaugh caught this at oral argument. If you mean something narrower, why would Congress keep borrowing the exact same phrase?
That's the question that writes the opinion.
Maybe, and Roberts had his own moment. The Solicitor General appealed to modern circumstances, birth tourism, changed migration patterns. Roberts cut him off. According to reporting on April 1st argument, he said, "Well, it's a new world, it's the same Constitution."
6 words, the whole case.
What's devastating about the domicile argument isn't just that it's textually weak, it's that if the court bought it, determining citizenship at birth would require a factual inquiry. Is this parent domiciled here? Justice Barrett flagged exactly that. A newborn citizenship left in legal limbo while domicile questions get sorted out.
That's a bureaucratic nightmare dressed up as constitutional theory.
And no one on that bench seemed interested in owning it, conservative or liberal. You know what nobody wants to say? The administration walked into that argument knowing the text was against them. That's why Trump was already posting the loss prediction before the ruling.
Which sets up the next question. When 6 justices are skeptical, how do they write the opinion? Because there are at least 2 paths, and one of them the media will completely miss.
That's where this gets genuinely interesting. Let's get into it. So the whole court basically looked at that domicile argument and said no. The New York Times flagged it after argument. 2 possible paths for ruling against the administration. Path 1, reaffirm Wong Kim Ark directly on 14th Amendment grounds. Path 2?
The INA.
Right, the 1952 Immigration and Nationality Act. Congress codified birthright citizenship in statute. The court could kill the executive order on that ground alone and never touch the constitutional question.
And Justice Kavanaugh actually raised that at argument, the constitutional avoidance doctrine. Decide on the statute, skip the bigger fight.
You know what nobody wants to say? That's the outcome cable news will completely miss. A narrow statutory ruling looks like a Trump loss on the scoreboard, win for the challengers, executive order dead, and every anchor calls it a defeat for the administration and moves on.
Okay, but Rush, is that actually wrong? The order gets blocked either way.
No, it's not wrong. It's incomplete. Here's what the statutory ruling leaves on the table. The constitutional question is technically unresolved. Any future president, this one, next one, comes back with a statute, or Congress passes something, and the fight starts over.
That's a fair point. A 14th Amendment ruling forecloses that. A statutory ruling doesn't.
Exactly. The ACLU's own lawyers told Kavanaugh they'd rather have the court reaffirm Wong Kim Ark on the merits. Their words, it would be prudent to go ahead and reaffirm it. Even the winning side wants the bigger ruling.
So the narrow path is the one that satisfies nobody completely.
And that's exactly why it's possible. Courts love a landing strip that avoids a fight. SCOB log flagged it. If there aren't 5 clean votes on the constitutional question, the statutory route becomes attractive.
Alito and Thomas were the 2 votes most sympathetic to the administration. That's a 7-2 or thereabouts if the court goes constitutional.
Right, which means 5 votes for reaffirming Wong Kim Ark isn't exactly hard math, but 5 votes for a specific constitutional rationale everyone agrees on, that's different. You could get a fractured constitutional ruling or one clean statutory one.
So tonight, watching the decision drop, what's the tell?
If the opinion leads with the INA and barely touches the 14th Amendment, that's the narrow ruling. The administration loses, the headlines say it's over, and it is absolutely not over. Watch for that. Now, here's where it gets interesting, actually, speaking of what the administration was selling to justify the order in the first place.
Birth tourism.
Birth tourism. And that part of the argument, not entirely made up.
Okay, so the policy concern, birth tourism. Let me just say it plainly. It's real.
It is real.
I'm talking about agencies. I'm calling them the womb concierge industry, charging anywhere from $15,000 to over $80,000 to fly rich Chinese and Russian nationals over here, set them up in maternity hotels, deliver the baby on U.S. soil, and hand you a passport application. That is an actual business model.
Over 500 of those companies reportedly operate out of China alone. That number came up on oral argument.
500. That's not a loophole. That's an industry.
Right.
And Trump actually said it on Truth Social. Quote, birthright citizenship is not about rich people from China who want it for pay. He's describing a genuine problem.
He is, and I'll give him that completely. Birth tourism is worth fixing.
But
the executive order wasn't a fix for birth tourism. It was a fix for all birthright citizenship. Every child, every undocumented parent. That's a completely different scope.
The problem is real. The remedy was wrong.
And there's the separation that matters. You can acknowledge the abuse without validating an unconstitutional executive order as the mechanism to stop it. Those are two separate questions.
So what's the constitutional fix? Because visa fraud enforcement, State Department rule changes, those exist already.
Exactly. Fact Check reported a 2020 Trump-era State Department rule that already created grounds to deny tourist visas for birth tourism purposes. That tool was already on the shelf.
So you're telling me there was a scalpel available and they went with a sledgehammer?
That's one way to put it.
Look, the womb concierge industry deserves every enforcement action it gets. I'm on board. But you don't rewrite 150 years of constitutional law to close a premium service immigration loophole.
And here's what nobody has been talking about. While SCOTUS has been consuming all the oxygen, the Justice Department has been running a completely separate track, denaturalization cases. And those numbers are something.
So while everybody's been watching the SCOTUS clock tick down, there's a whole other machine running in parallel, and the press has completely buried it.
CBS News reported it straight. The DOJ plans to file at least 250 denaturalization cases in federal courts by September 30th, end of fiscal year.
250. Now hold on. Let me put that number next to something. From 1990 to 2017, that's 27 years, the government averaged 11 denaturalization cases per year.
11
per year for nearly 3 decades.
And now, 250 by October.
Yeah, sit with that. Wow. And it doesn't stop there. Internal USCIS guidance, reported by the New York Times, directs field offices to refer 100 to 200 cases per month to the DOJ for fiscal year 2026. That's potentially 2,400 cases annually.
Hold on, that's the referral pipeline rush. Those don't all become filed cases. But even if a fraction do, you're talking about a structural transformation, not an enforcement uptick.
Exactly. But I want to make sure people understand what we're even talking about, because this is not the birthright citizenship fight.
Right, completely different legal track. Denaturalization targets naturalized citizens, people who went through the immigration process and got citizenship through naturalization, not people born here. These are two separate legal mechanisms running simultaneously.
2 tracks. The SCOTUS case argues about who gets citizenship at birth. The DOJ track argues about whether citizenship already granted can be taken back.
And the government has actually been winning those. According to track reports, they track federal filings. At least 33 new cases were filed in May and June 2026 alone, and the DOJ went 8 for 13 in cases it filed in 2025.
8 out of 13. So they're not just talking, they're winning.
That said, the legal standard is genuinely high. The burden is clear, convincing, and unequivocal evidence. Federal court every time, no administrative shortcut.
Which is where it gets complicated, because the government is also building a quota system. And the question nobody wants to ask,
Can you maintain that standard at 250 cases by fall and then potentially 2,400 a year?
That's the question sitting right underneath all of this. And it connects to something bigger than the case count.
It does. Because when you pull back, the birthright fight and the denaturalization push aren't two stories. They're the same argument, and that argument has an asterisk in it.
I think you're going to need to explain that asterisk.
Oh, I'm going to.
So let me give you the unified theory here. 2 tracks, 1 argument. The administration is saying American citizenship has an asterisk.
An asterisk?
Born here to the wrong parents? Asterisk. Naturalized, but the DOJ found a paperwork problem from 1999? Asterisk. We all know what's really happening here. They're not attacking the ceremony, they're attacking the permanence.
And UVA law professor Amanda Frost nailed it. She's written that the administration has targeted 700,000 naturalized citizens for investigation, and the chilling effect alone changes behavior. Permanent residents stop applying for citizenship entirely.
700,000 flagged for investigation?
Yeah, and Frost's point is that a quota-driven system creates its own pressure. When you're aiming for 250 cases by October, the incentive shifts from find the worst fraud to meet the number.
That's the thing that should scare everyone. Left, right, doesn't matter. The legal standard for denaturalization is clear, convincing, and unequivocal. That bar exists for a reason.
The Sally circular matters, but we shouldn't take our eyes off the bigger picture. What does it mean to create a definition of inconsistent application? How do you find that line between simple human error and something more malicious?
Right. The assembly line is fine until it isn't. And once the precedent is set at scale, the asterisk becomes standard operating procedure.
Frost also flagged something darker. Historically, denaturalization got weaponized against ideological opponents, the 1950s Red Scare. It hasn't happened yet in this cycle, but the infrastructure is now built.
The machinery matters. Even if you trust the people running it today, machinery doesn't expire when administrations do.
That's the argument that outlasts today's ruling.
So tonight, the networks are going to flash a chyron. Trump loses birthright citizenship case. Full stop. End of story.
And if it's a statutory ruling under the INA, that's exactly the wrong read.
The constitutional question stays open. A future executive tries again with a different argument, and this ruling doesn't stop them. That's what nobody is going to say on cable.
And the denaturalization push, 250 cases targeted by October, that train doesn't stop regardless of today's outcome. CBS News had this on the record from a Justice Department official.
2 completely separate tracks.
Right.
One ruling doesn't touch the other.
Read the actual opinion, not the summary. The holding and the reasoning are going to tell very different stories.
That's exactly why we're here today, before the networks got to it first. All right, bottom line today. The Supreme Court is out of time. Trump v. Barbara gets decided, and the question isn't just birthright citizenship. It's whether an executive order can rewrite what the 14th Amendment actually says.
And the Wong Kim Ark move they tried, borrowing the precedent to redefine domicile, didn't survive the oral arguments. Roberts, Kavanaugh, justices across the spectrum saw right through it.
The president predicted his own loss on Truth Social, in writing. That's the episode right there.
And don't sleep on the denaturalization track. That runs regardless of how today goes.
2 separate fights. One ruling won't end either of them. Watch tonight's coverage carefully. The narrow ruling trap is real.
That's the homework.
If this show gave you something to think about, subscribe, drop us a 5-star review, send it to someone who needs it. New episodes every weekday.
Thanks for being here. We'll see you tomorrow.
Stay sharp.